Laura Anthony, founding partner of Legal & Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about direct public listings. There are some fundamental differences between the direct listing process for OTC markets and for a national exchange. In particular, when completing a direct listing onto a national exchange, the exchange issues a trading symbol up front, and the shares are available to be sold by the selling stockholders at prevailing market prices at any time after trading begins. In an OTC markets direct listing, a company must work with a market maker to file a 15C 211 application with FINRA to obtain a trading symbol. When completing a direct listing onto OTC markets, the registered securities may only be sold by the listed selling stockholders at the registered price, regardless of prevailing market prices. However, once a company is trading on the OTCQB or OTCQX tier of OTC markets, and as long as the offering is not considered an indirect primary offering, the company could amend the registration statement to allow shares to be sold at market price. Generally, an offering will be considered indirect primary if more than 30% of the float is being registered for resale. Overall, the direct listing process is a little less expensive and a little quicker than a direct IPO process. The reason for this is that the company can work with a market maker to apply for a trading symbol immediately upon effectiveness of the S1, as opposed to having to wait until after an offering has been sold and closed out. I will now begin summarizing the direct listing process for an OTC markets listing. To begin, a company should retain its team, including legal, accounting, and auditing. The company will also need a transfer agent and an Edgar agent, also called a financial printer. Our firm often makes referrals and recommendations to various other service providers that are needed. A company may also use a broker-dealer placement agent in the private offering phase, although it's not necessary. Generally, counsel will prepare a full transaction checklist, including who is responsible for what items from the beginning until completion of the direct listing. The beginning of the process includes gathering due diligence and completing any corporate cleanup or reorganization that may be necessary in advance of a public listing. All companies need some level of cleanup, which could include amending articles of incorporation and bylaws to make them more public company friendly, to creating employee stock option plans, entering into employment contracts with key officers, ensuring that licensing agreements and intellectual property rights are secure, adding board members and committees, such as an audit committee, and establishing corporate governance, including an insider trading policy. While the company's accounting and auditing are being completed, legal counsel will complete corporate cleanup and begin to draft the private offering documents if the company is completing a new private offering round. Sometimes the company begins the process after several prior rounds and offerings and will not complete another one. In addition, legal counsel, together with the investment bankers, if any, and other advisors, will work with the company to determine valuation and the best structure for the private offering and the registration statement pricing. The final registration statement pricing will not need to be determined until the final pre-effective amendment is filed with the SEC. In the next LawCast in this series, I will continue summarizing the process. I'm securities attorney Laura Anthony, founding partner of Legal & Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.